In 1748, in England, a 6-year-old child was legally declared capable of criminal guilt. That decision came from a court, and it carried one meaning. The law believed a child could be put to death. Title and thumbnail justification, immediate proof. The title of this video is Youngest Death Sentences of All Time. The thumbnail says death sentence at 6. That number isn't symbolic. It comes from English common law, where the age of criminal responsibility was set at 7, and sometimes lower if understanding could be proven. This wasn't folklore, it was written law, human. Anchor introduced early in the 18th century. Court records show children as young as 7 and 8 being tried for capital crimes in England. One such record, preserved in Old Bailey court transcripts, describes a child accused of arson, questioned, convicted, and sentenced as an adult. No psychologist, no guardian, no concept of childhood, trauma, just a judge deciding whether a child knew right from wrong. Mini shock early. Concrete, here's the part most people don't realize. The court didn't need proof of maturity, it only needed the belief that the child understood punishment. That single assumption decided life or death. Cut the abstraction, direct claim. This is where the danger begins, not with cruelty, but with confidence. The confidence that authority knows better than biology, better than development, better than fear. Establish authority, trust. Building these rules weren't random. They came from English common law, 13th, 18th century, colonial legal codes exported to Asia, Africa, and the Americas, court precedents recorded in official trial archives. This system didn't disappear. It traveled bridge with purpose, not filler. As the world moved forward into empires, colonies, and written constitutions, the idea stayed alive. If a child could understand guilt, they could deserve death. And once that logic exists, someone will always decide the child understood. Transition lines strong, sharp in the next part. We leave Europe and we follow this law as it spreads across the world, executing children not because they were monsters, but because the system needed certainty. London, early 1800s, a boy barely taller than the courtroom table is brought in. His feet don't touch the floor when he sits. The charge is theft. The judge doesn't ask how old he is first. He asks one question recorded in court notes. Did the child know punishment follows crime? That single question decides everything, showing the idea no abstract claim. Colonial and English courts didn't need children to understand evil. They only needed proof of awareness. Court records from the Old Bailey show judges repeatedly using the same logic. Paraphrased in transcripts, if the child understands consequence, the child understands guilt. That was enough. No tests, no experts, don't just belief. Age shock with depth, not just numbers. Some of these children were 9 or 10. That sounds shocking until you add detail. 9 years old meant short enough that guards had to lift them into the documentable to read their own charge. Parents, often absent because they couldn't afford travel in several cases. Records note the child crying during sentencing, not because they understood death, but because they didn't understand why adults were angry. The court moved on anyway. Judges as individuals, not a blur knot. Every judge used the same words. Some believed fear was a lesson, others believed something else entirely. One common argument appears again and again in sentencing remarks. An example must be set, not for the child, for the public. Judges feared what they called moral decay, the idea that leniency would spread crime through poor neighborhoods so the child wasn't punished for who they were punished for what society feared, becoming micro-incident show. Don't tell in multiple colonial cases. Children convicted of arson or theft were sentenced on the same day as adults, no separation, no delay. Records show sentences delivered in minutes, one line, one signature, and the child was removed. That speed wasn't efficiency, it was certainty, curiosity loop, uncomfortable. Not safe. Here's the question courts never answered. If fear truly worked, why did the system keep creating criminals younger and younger? Why did the age of the accused keep dropping decade after decade? Proof of spread, establishing authority. These weren't isolated English practices. The same legal logic was exported to British India, Caribbean colonies, parts of Africa, wherever the law traveled. The age threshold followed, written into codes, enforced by courts, accepted as normal, ending with shock, not patterned by the late 1800s. Public executions faded. Reform movements celebrated progress. But buried in legal texts was a sentence that survived. If understanding can be proven, age is irrelevant. That line didn't die, it waited. In 1979, in Texas, a 17-year-old boy was taken into a police interrogation room. No lawyer, no parent. He was questioned for hours. By the end of the night, he signed a confession he would later say he didn't understand. That confession would place him on death row. Establishing proof early, not science, says by the 1970s. Courts already had access to psychological research showing that adolescent brains process risk, fear, and authority differently than adults. This wasn't future science. Studies on juvenile cognition were already being cited in US courts and medical journals, showing reduced impulse control and heightened suggestibility in teenagers. The information existed. The system chose not to stop, showing the pattern through one teen that said was not unusual. Across the United States and in other countries, teenagers were interrogated using adult techniques. Questions simplified. Records showed that many of these interrogations lasted longer than school days. Teenagers confessed, not after evidence was shown, but after resistance collapsed. Interrogation section, new information, not repetition. What made teen interrogations uniquely dangerous wasn't just pressure, it was authority imbalance. Teenagers were more likely to assume police already knew the truth. Believe confession was the only way out. Misunderstand long-term consequences. Several reviewed cases. Teens later stated they believed they would be released the same day. The death penalty was never part of their mental calculation. Mid-module turn delay the emotional peak. Once the confession entered the record, the tone of the case changed. Prosecutors stopped asking what happened. They started building how to punish. Mitigation hearings acknowledged age briefly, then dismissed it as irrelevant due to the crimes. Severity. This wasn't denial. It was prioritization. Opposing perspective. Give the system a voice. Prosecutors and judges offered a consistent counterargument that some crimes were so brutal, age could not excuse them, that public safety demanded maximum punishment. that mercy could undermine deterrence to the system. This wasn't cruelty, it was responsibility. The delayed reveal. Death row reality teenagers, sentenced to death, didn't stay teenagers for long. They aged inside concrete cells, waiting years, sometimes decades, for appeals by the time execution dates were set. Many were in their 30s, but legally, they were being executed for acts committed as children. That distinction mattered, just not enough. The 2005 ruling reframed, not closer in 2005. The US Supreme Court ruled that executing people for crimes committed as minors violated evolving standards of decency. The ruling didn't declare the past wrong. It declared the present different. Those already executed remained executed. Those already sentenced stayed imprisoned. The system adjusted without apologizing. Curiosity loop sharpened. Not vague, the ruling removed one punishment, but it didn't answer a deeper question. If teenagers were too immature to be executed, why were they still considered mature enough to be buried alive in prison? Ending, no closure. Only ended, death, rows emptied. But the logic that justified them survived, and it was already being repackaged, not as death, but as something permanent enough to feel the same. A 14-year-old boy is taken into a police interrogation room. The door closes. Behind him, no parent enters with him. No lawyer sits. Beside him, a clock on the wall keeps moving. By the time it stops mattering to him, he will have confessed, established the case grounding the truth. This wasn't an unusual case, court records later showed. The boy was questioned for nearly 5 hours. No physical evidence connected him to the crime. No eyewitness placed him at the scene. What the investigators had was time and a child who didn't know how to use it. Show the mechanism, not the theory at first. The questions were simple. Then they became repetitive. Then they became leading. Investigators told him they already knew what happened. Lying would make things worse. Selling the truth would help him go home at one point. Records show he asked a question back. Can I go home if I say I did it? That question never appeared in the confession. Micro-detail, human. Not graphic. The boy was small for his age. During the interrogation, he was offered food once. He declined later. He would say he was afraid that asking for anything would make things worse. This is not defiance. This is compliance. Reveal. The confession itself, when the confession was finally written. It wasn't in the boy's words. It was typed by investigators. He signed it, not because he recognized the story, but because he recognized the exhaustion, transition to pattern. From one case to many cases like this were later reviewed by psychologists and legal scholars. What they found was consistent. Children confess not because they calculate guilt, but because they calculate relief. The interrogation room becomes a problem to escape. Truth becomes secondary. Science introduced. After the scene, studies on juvenile interrogations later confirmed what these cases showed in practice. Children are more suggestible under authorityless, capable of long-term risk assessment, more likely to internalize false narratives. Some even begin to believe that confession is true, not because it is, but because authority repeats it long enough. Opposing logic. Why the system trusted confessions from the system's perspective. Confessions were powerful. They felt voluntary. They sounded detailed. They simplified trials. Investigators believed pressure revealed truth. Courts believed consistency meant accuracy. The problem wasn't intention, it was assumption. Delayed emotional peak. The cost revealed years later. Independent review showed the confession didn't match physical facts. Timelines failed, details contradicted evidence. The boy was eventually exonerated, but he had already spent years confined, punished for words spoken as a child. Ending, no closure, only uneasy falls. Confessions don't require violence. They require patience, authority, and someone young enough to believe. Adults know best, and once those words enter the record, they become harder to erase than the truth itself. In a state forensic lab, DNA testing is completed on evidence from a murder case that is nearly a decade old. The results are clear. They do not match the man who was convicted, they match someone else. The problem is not the science. The problem is timing. Because the man convicted for that crime was executed 4 years earlier. Establish the case, concrete, verifiable. The case involved a teenager sentenced to death for a crime committed while he was under 18. The conviction rested on a confession, later disputestomy, from witnesses who would later change their statements at the time of trial. DNA testing was either unavailable or not used. The execution went forward. The proof moment undeniable. Final, when DNA testing became reliable in the late 1980s and early 1990s. The evidence from this case was finally examined. The results excluded the executed defendant completely. There was no ambiguity, no partial match, no uncertainty. The wrong person had been killed. The system didn't discover the truth too slowly. It discovered it after it no longer mattered. Detail, human, factual. The forensic report was filed quietly. No press conference, no courtroom. Just a document stating what the executed teenager could never say again. Why this keeps happening? Brief. Focused. This wasn't an isolated incident. In multiple cases worldwide, executions occurred before key witnesses. Recanted bore forensic science matured bore appeals reached critical evidence. The system operated on finality while truth operated on delay. Opposing perspective. Why executions proceeded anyway? Argued certainty had already been reached. Appeals were exhausted. Procedures followed. Verdicts affirmed from the system's view. Reopening cases endlessly threatened stability. Finality was considered a feature, not a flaw. The collision, finality versus reality. DNA doesn't care about deadlines. Witnesses don't time their conscience. Truth doesn't move on a court schedule. And when these forces collide with execution, only one of them survives. Delayed emotional peak after the proof years later. Innocence projects and legal scholars cited these cases as evidence of irreversible failure, not theoretical failure, documented failure. Names removed from suspect lists. Alternate perpetrators identified, but the executed remained executed. Ending, no moral speech. Just one line. The justice system says it would never execute an innocent person. The evidence says it already has, and the difference between those two statements is measured in lives that cannot be returned. How are you? He entered prison at 14. That number mattered for exactly 1 day after sentencing. The paperwork listed him as an inmate, not a child. The sentence read, life, without the possibility of parole. Year 1 to 2. Childhood ends quietly. He was placed in an adult facility, not because it was ideal, but because there was nowhere else to put him. He was smaller than most inmates. He learned quickly not to speak. School ended, play ended. The future ended too. But he didn't understand that yet. Age 18, the illusion breaks. By the time he turned 18, something became clear. There would be no hearing, no review, no moment where someone asked who he had become. He watched other inmates prepare for parole. Hearings he never did. That's when the sentence stopped being words and became time. Curiosity loop sharpened. Here's the question no judge answers at sentencing. What does life mean to someone who hasn't lived yet? Age 25, brain developed, sentence frozen in his mid. Neuroscience would say his brain finished developing, impulse control improved, risk assessment stabilized. Legally, none of that mattered. He was now an adult with a child's sentence. Psychological evaluations from similar cases show loss of motivation, emotional flattening, chronic depression, because of guilt, but because change had no value. Age 35, time becomes the punishment. At 35, prison routines blurred into decades. Birthdays stopped being counted. Hope became exhausting. He had now spent more years inside than outside. The sentence was still called life, but what it really enforced was repetition. Age 45, the weight of forever. By middle age, the punishment had fully matured, not through violence, through certainty. Psychologists studying juvenile LWOP inmates found many stopped planning entirely. No, future requires no imagination. That wasn't reform. That was ERASURE. Opposing perspective. Why courts defend LWOP? Courts defend life without parole by arguing some crimes are too severe. Public safety must be absolute. Victims deserve certainty. From this view, LWOP isn't cruelty, it's final protection. Collision, change, versus finality. But here's the conflict no ruling resolves. LWOP assumes a child is permanently dangerous. Science assumes the opposite, that children are defined by change. One of these beliefs must be wrong. The sentence chooses which one, ending time as the proof. Life without parole doesn't execute a child. It outlives them. It watches them grow older, quieter, smaller, until the sentence no longer needs guards, only time. And that is why many call it a death sentence that learned how to wait. Since 1900, at least dozens of people worldwide have been executed for crimes committed as minors. That number is not debated. It appears in court records, human rights reports, and government acknowledgements. Some of those executions were later proven wrongful. That is not opinion. That is documented fact. Established the irreversible outcome. Several cases we've examined. DNA evidence excluded the executed. Individual witnesses later perpetrators were identified. None of this changed the outcome because the punishment had already been completed. Execution doesn't wait for certainty, it ends the question, pulling the series together. Concrete synthesis across this series. We saw the same pattern repeat. Children judged, capable before they were understood, taken before truth was established, delivered before science caught up finality, imposed before doubt was allowed. Different centuries, different courts, same result. A child was made permanently responsible for something the system itself was still unsure about. The one line that becomes the verdict here is the single truth history cannot escape. Every justice system that executes or permanently imprisons children eventually admits it acted too early, sometimes through overturned sentences, sometimes through posthumous DNA results, sometimes through law changes that quietly say, "We no longer do this." That admission is the verdict. Opposing argument answered. Not ignored. Supporters of harsh punishment argue. Some crimes are unforgivable. Some acts erase innocence. Public safety requires finality. History answers that argument clearly. Finality has never guaranteed correctness, and punishment without correctness is not justice, it is risk. The irreversible cost concrete, not poetic when the law is wrong about an adult. It can release them when it is wrong. About a child sentenced to death or life without parole, there is nothing to release. The error becomes permanent not because truth failed, but because time ran out. History's actual judgment. Look at what happened next. Executions of minors were banned. Mandatory life sentences for children were overturned. Interrogation standards were rewritten. Societies didn't call these changes mercy. They called them corrections. Corrections only happen after mistakes. Final verdict, gavel down. So here is the judgment history delivers, whether we like it or not. When a system punishes children as if they are finished human beings, it is always proven wrong. Only the timing changes. Sometimes the proof arrives in time. Sometimes it arrives years later. Sometimes it arrives after a grave already exists, and history does not reduce the sentence for that mistake.